We have a second bankruptcy case going to the Supreme Court this term. The justices granted certiorari to the First Circuit in a case called Mission Product versus Tempnology. The decision is going to be very important in the commercial arena, and it's also going to give us an idea about what the justices believe the consequences are of rejection of an executory contract. The heritage of the Mission Product case goes all the way back to 1985 and to a Fourth Circuit decision, a very controversial decision known as Lubrizol. In Lubrizol, the Fourth Circuit said that rejection of a license for intellectual property bars the licensee from continuing to use the property, such as trademarks, patents, and technology generally. Well, that decision by the Fourth Circuit very much bothered Congress, which roared to the defense 2 or 3 years later and amended the Bankruptcy Code to provide that many kinds of intellectual property, for instance, patents, can be used after rejection if the licensee so rejects. However, Congress was silent about trademarks. As a result, most courts have held that if you reject a trademark license, the licensee has to stop using the mark. Well, that was a case until I think it was 2012, when the Seventh Circuit decided the Sunbeam decision and held that, well, outside of bankruptcy, if a licensor breaches a trademark license, that is never going to stop the licensee from using the mark. Well, as it turns out, the First Circuit rejected Sunbeam explicitly, and the justices granted certiorari to resolve the split among the circuits. We suspect that this case will be argued in February, which means we will have a decision sometime in the spring, certainly before the Supreme Court term ends. I should add, by the way, that there is another case that is a very good candidate for certiorari. It deals with the automatic stay and how automatic the automatic stay is. However, the final brief opposing certiorari is not going to be filed until mid-December, and so it's, I think, unlikely that case can be argued before the end of this term. However, it could be argued very soon after the term begins in October of 2019. To read more about these cases, read my column, Rochelle's Daily Wire, on the ABI website. And meanwhile, be well, stay out of trouble, and we'll be back same time next week with another important event in the world of bankruptcy law. Until then, this is Bill Rochelle, ABI's editor-at-large, saying good day.